A fresh opportunity, rollback of the Personal Data Protection Bill. The stated reason बताया गया कारण for the government's withdrawal of the Personal Data Protection Bill, 2019, was that it will come up with a comprehensive विस्तृत legal framework on data privacy and internet regulation विनियमन. The government has averred औसत that a new draft will be in sync with the principles of privacy, in line with Supreme Court guidelines based on the landmark judgment on privacy, i.e., Justice K.S. Puttaswamy vs. Union of India, and would consider vichar karna the Joint Committee of Parliament's recommendations सिफारिशों on the framework to regulate विनियमित the digital ecosystem digital पारिस्थितिकी तंत्र. The 2019 bill had been rightly criticized आलोचना की by stakeholders, including Justice B. N. Srikrishna. He chaired Adhyakshata, a committee of experts that had authored a draft bill in 2018 for overemphasizing the national security angle, among other reasons. The 2019 bill diverged alag hue from the Srikrishna committee draft in the selection of the chairperson and members of the Data Protection Authority (DPA) that shall protect the interests of data principles, and in the leeway given to the union government to exempt its agencies from the application of the Act. The 2018 draft bill allowed for judicial oversight (nigrani) in the selection process for the DPA, while the 2019 bill limited the composition to the executive. The 2018 bill allowed for exemptions to be granted to state institutions from acquiring informed consent anumati from data principals or to process data in the case of matters relating only to the security of the state. It also called for a law to provide for parliamentary oversight and judicial approval of non-consensual bina sehmati access to personal data. In contrast, the 2019 bill added public order as a reason to exempt a government agency from the Act, besides only providing for these reasons to be recorded in writing. By choosing to withdraw the bill, it is unclear whether the government would address the demand for a realignment punarnirman karna of the legislation with the 2018 draft bill that came about after extensive consultations vyapak paramarsh with civil society. Or whether this would be more in line with the JPC report, which has also been criticized आलोचना की by civil society for retaining बनाए रखने की provisions that allow the government access to private data of citizens without sufficient safeguards. Dissent Matbhed notes to the JPC report, by Congress MP Jairam Ramesh for example, went on to criticize the leeway granted छूट दी गई to the government on exemptions छूट and how the ground of public order and not security of the state was liable उत्तरदायी for misuse. It is not clear if the bill's withdrawal is linked to opposition to mandatory anivarya data localization from multinational internet companies. Meanwhile, the lack of a proper data protection law in the country is an anomaly visangati when compared with major countries. If the government is indeed committed to a comprehensive legal framework on data privacy and protection, it must revert fir lautana to the baseline provided in the Justice Sri Krishna Committee recommendations and enact Abhinay Karna, a law within a reasonable timeline.